University. I welcome everyone in the post-lunch session. So this is the second substantive session which we are heading towards. Professor Anil Kumar Rai is the chair of this session. Professor Anil Kumar Rai is currently a professor at National University Delhi. Previously he taught at National University of India, Bangalore, and St. Andrews College, Gorakhpur, Campus Law Center, Delhi University. He has specialized in international law and criminal law. Prior to joining NMUD, he was a partner with Luthra and Luthra Law Offices. Professor Rai holds LLB from Gorakhpur University and LLM from Delhi University. Now I hand over the session to Professor Rai and also to introduce the other speakers. Thank you very much.
Yeah. Welcome to the afternoon session. I think that we had a filling lunch. Hope you keep awake despite that lunch. And I hope that our speakers for the afternoon this session have enough discussion for you to keep awake. Now, this session which we start, our first speaker is Dr. Suryadev. Now, Dr. Suryadeva is Associate Professor at City University of Hong Kong, and his areas of interest are business laws, human rights, corporate social responsibility, and comparative constitutional law. He is presenting a paper on the state of Indian state times up for the instrumentality test. Over to Mr. Professor Suryadev.
Thank you very much, Professor Rai, and very good afternoon to all of you. It's always difficult to start after the lunch, as the chair already highlighted, but let us see how we go about it. So in this paper, the central argument that I am trying to construct is that the instrumentality test that the Indian Supreme Court has developed over the years is inappropriate, inadequate, and unsound normatively. Why it is inappropriate? Because if you look at the Ajay Hashia variables, and I will discuss that a little bit later in more detail, most of these variables focus on the creation or the composition of the given entity rather than on the functions or the impact of those functions on the fundamental rights, and that's why in my view the test is inappropriate. It is also inadequate because at this point of time there are many private sector companies which do not really compare well with the public sector undertakings, because the test was developed in the context of public sector enterprises predominantly. But post 1990s, we do not have merely big public sector undertakings as the market players, and that's why the test is inadequate to capture a wide variety of private companies that might violate fundamental rights. Thirdly, the test is also unsound normatively, because to avail the protection of fundamental rights against a particular entity, it has to be an agency or instrumentality of the state, meaning thereby it has to be a state. Only then you can invoke fundamental rights. And this is unsound because if you look at the developments both under international human rights law and even in constitutional law in the more recent times, the horizontal application of human rights is the predominant paradigm. And it does not really matter from the victim's point of view whether the violation is done by the state agencies or the private actors, from the victim's point of view. And that's why the normative unsoundness is there. That's why the second argument that I would like to propose is that there should be a liberal understanding of the concept of the state for the purpose of fundamental rights. Because there is no point in having a very broad review of Part 3 of the Constitution where we have multiple rights being created, which some scholars call overproduction of fundamental rights. At the same time, we have a narrowing concept of Article 12, so that overproduction is not going to be useful in practice. So this liberal understanding of the state, in my view, is supported by three independent but interrelated arguments. The first is, if you look at the debates of the Constituent Assembly, and again I will cite Dr. Ambedkar on this point, the intention of the founding fathers was to create the concept of other authorities in a very broad sense. Secondly, if we look at the Indian theory of human rights, and here I will rely on Sir's paper, that the Indian conception of human rights is very different from the Western concept of human rights, and it could apply even to private non-state actors at the horizontal level. And nicely connected with this proposition is the developments in international human rights law, in particular the adoption of the guiding principles in business and human rights in June 2011 by the Human Rights Council, where they expressly talk about that all business enterprises have a responsibility to respect all human rights. So, because of this development under international human rights law, the position of the Indian Constitution or the instrumentality test is inappropriate. The third point that will support a liberal understanding is that if you look at the more recent constitutional developments, whether it is the Constitution of South Africa and Ramakrishna mentioned even the Nepalese Constitution, some provisions are applicable to non-state actors. And also there are constitutions in Latin American traditions where amparo proceedings are available against private actors. So these are the three independent basis on which we can support liberal understanding of the concept of the state under Article 12 of the Indian Constitution. Now let us go back to Ajay Hashiya, the 6 variables that have been laid down by Justice Bhagwati in that particular case. The first is that the entire share capital of the corporation, that is the first. Second is the financial assistance given to the company by the state. The third is the corporation enjoys the monopoly which is conferred or protected by a state. The fourth is deep and pervasive state control. Fifth is function of the corporation is of public importance and closely related to the governmental functions. And lastly, department is transferred to corporation. If you look at these 6 variables, most of these make sense in the context of public sector enterprises. They do not make sense in the context of private companies that have come into play a dominant role post 1990s in India or anywhere else in the world at this particular point of time. Because entire share capital, public sector company we're talking about. When we look at the financial assistance, again we are looking at how the company is being given assistance by the state. So some grants could be given by the state, for instance. Monopoly status, again we are looking at those particular kind of companies. Deep and pervasive state control, you will not have normally against private company situations. So the only one test which could have, one variable of this test which could have some relevance is that the function of the corporation is of public importance. But the difficulty is that this test has 2 limbs. The first is that the function is of public importance, but the second limb is that it's closely related to the government function. And because of these 2 limbs in this one variable of the test, again it becomes in practice very difficult to apply it in the situations of private sector enterprises. Now, if you look at the application of this test, in the morning session MC Mehta was cited, and of course there was no conclusive finding in this particular case. But I think there have been other judgments, including most notably the judgments in cases involving the Board of Control of Cricket in India, BCCI. And there have been a couple of judgments around 2004, 2005, and then more recently 2015. And if you look at those judgments in the majority opinion, the Supreme Court is basically saying that yes, BCCI is very powerful, it has almost the monopoly over the game, it has extensive powers to ban cricket players, it has the powers to select cricket players. So because of all these things, it looks like a very powerful entity. And then there should be some element of fairness this entity's function should be subject to, but the majority judgment says that still it is not other authorities as per the instrumentality test under Article 12 of the Constitution. So meaning thereby the BCCI could violate almost all fundamental rights unless we apply them at the horizontal level, and some of them are available in that particular context. So that is the difficulty. Then there was this 2000 judgment in the Biswas test, Deep Kumar Biswas case, where I think a 7-judge bench is in fact going further and propounding a more rigid test that the authority should be financially, functionally and administratively dominated by the government. This is very impossible threshold to satisfy against many private companies. Financially, functionally, administratively. So again, what I'm trying to suggest here is that the mindset of the court is that they are trying to come up with these variables of the test, keeping in mind public sector undertakings. The Supreme Court has not evolved to the post-1990 situation in which there could be a number of big private companies which are not at all linked or similar to the public sector enterprises in this particular context. Some scholars have made the argument, including Sir, that some of the fundamental rights at least, which are not expressly linked to fundamental rights, could be extended to non-state actors. And even Supreme Court, for instance, has dealt with in Article 21 that sexual harassment private companies are within the purview of Article 21. My difficulty is that Article 21, as interpreted by the Supreme Court, includes not merely sexual harassment as a fundamental right, or the protection against sexual harassment to be more accurate. There are a number of rights: right to clean environment, health, right to food, and all this, so on and so forth. Whether all these rights, let us say there are people starving on the streets of Delhi, can they avail this right to food against non-state actors? Because right to food, let us say, if it is implicit in 21, can that protection be extended? Same could be applied in right to health, though there are some judgments where the court have said that private hospitals should not decline to admit patients, and recent dengue cases illustrate that issue again, that when private hospitals decline to admit patients for a number of reasons. So here the question is going to be about the judicial selectivity. When it comes to sexual harassment or the protection against it, the Supreme Court said that okay, we can apply this to the private sector, but what about so many other rights that have been implied into Article 21? So what is the basis on which the Supreme Court will apply selectively some of the rights which are read into Article 21 against the private non-state actors? So in short, what I'm trying to suggest by now is that the instrumentality test is definitely not going to work in future. And it's not working already, as some of the judgments we know, because if the Cricket Control Board of India is not a state, how many powerful entities we have in India as compared to the Public Cricket Control Board of India? It is economically very powerful, it has the monopoly. The court is saying, oh, the monopoly is not conferred by the state. But the monopoly need not be conferred by the states merely by a positive action. The state by non-action could also confer monopoly on the Cricket Control Board of India, and I think that is what is happening in this particular situation. Now let me try to unpack the three strands of the reasoning that why we should have a more liberal understanding. During the Constituent Assembly debates, two members of the Assembly, Nazruddin Ahmed and Mehboob Ali Beg, they expressly said that we need to delete this part of the sentence which talks about the other authorities in Article 12, which used to be draft Article 7 at that particular point of time. And Ambedkar responded that no, we need to have these words in Article 12, and I quote Ambedkar on this. Quote, they must be binding, they means fundamental rights, they must be binding on every authority which has got either the power to make laws or the power to have discretion vested in it. I do not see anyone who cares for fundamental rights can object to such a universal obligation being imposed upon every authority created by law. And of course later on, unquote. And later on, of course, the distinction between created by law, created under the law has also not been considered that crucial. So the point is that if we look at the response of Dr. Ambedkar during the framing of Article 12, it becomes clear that his intent at least was very much to provide a liberal understanding of the concept of other authorities in Article 12 of the Constitution. And when we talk about the power to make law, because he talks about the authority which has the power to make laws, or which has the power to have discretion vested in it. Now what is the power to make law? If you read this in the context of Article 3, Clause 3, Subclause A, what is law? It talks about ordinance, order, bylaw, rule, regulation, notification, custom, usage. Some of the social customs are not created by the state. They could be a village custom, and that custom is law for the purpose of Article 13, and that custom cannot violate fundamental rights. So the point is that custom could be created by non-state actors, which are not covered by the instrumentality test. This is also something to be relevant. The last point which I would like to make here is, because I may not have enough time to make all the arguments, is that in Article 12, there are two concepts that you find after other authorities. One is, these are under the control of the Government of India, and the second is within the territory of India. And there is an or in between these two, within the territory of India or under the control of the Government of India. Now this phrase, under the control of the Government of India, was not there in the original draft Article 7. It was inserted on the request of Dr. Ambedkar at the very last moment, meaning thereby we could have an Article 12 which would say that other authorities within the territory of India, it need not be under the authority of India. And again, there is an or in between. So as long as there is an authority within the territory of India, that should be sufficient in my view. It need not be under the control or under the authority of the Government of India. And of course, if we look at international human rights law, I was talking about the guiding principles on business and human rights, which were adopted, and now at the UN level they are negotiating a treaty dealing with business and human rights, which will impose perhaps direct human rights obligations on all business enterprises. And if we combine this with the comments of the Committee on Economic, Social and Cultural Rights at the UN level, again, which they talk about that the rights under the ICSCR are not limited to merely state and state agencies. Even the private non-state actors have these human rights obligations in this particular context. And this connects nicely somewhat with the argument made by Professor Singh that the Indian conception of human rights is different from the Western idea, and some rights in the Indian society's context are relevant at the horizontal level as well. Untouchability is a good example, child labor is another example. And I think Professor Ved Kumar was talking about the violations taking place in the private sphere. So violence against women, for instance, or the practices which are discriminatory in the private sphere, that would also fall in this particular category where the protection should be available beyond the state agencies. My third and the final strand is that if we look around the world, Indian Constitution was drafted more than 65 years ago. But if we look at the constitutions which are being drafted in more recent times, or if we look at the case law of more recent jurisdictions, not everywhere, but in some jurisdictions, they definitely support the view that the idea of a state for the purpose of human rights or fundamental rights is getting more and more liberal. I would like to cite a couple of examples here. One is section 8.2 of the Constitution of South Africa, and I quote, "Bill of Rights binds a natural or a juristic person taking into account the nature of the right and the nature of any duty imposed by the right." Unquote. So the Constitution of South Africa, which was adopted in 1996, very clearly talks about that all the fundamental rights under the South African Constitution can be availed against private actors. But they have imposed certain limitations which could be judicially interpreted. In the morning, Ramakrishna was also alluding, and I would like to look more closely at the Nepalese constitution, which will be adopted tomorrow, which will be enforced, I guess, from tomorrow. That how they have extended, on what basis they have extended certain fundamental rights against private actors. But I would also like to mention a provision in the Greek constitution which says that the constitutional rights also apply to the relationship between individuals wherever appropriate. So again, there is a qualification there. My last example is what we know as amparo proceedings. Amparo proceedings are in civil law jurisdictions which are similar to the writ proceedings. And in many countries in Latin America, Colombia for instance, Mexico, in Philippines too, these amparo proceedings can be invoked against private non-state actors. So you could rely on a fundamental right in the constitution, and if it is violated by a private company, it could be invoked. Some kind of a remedy could be invoked against the private non-state actor. So these were the three strands of the argument that supports that we should have a liberal understanding in this particular context. So just to sum up and conclude, because the time is running out and I do not have the time to, for instance, refer to, there is a recent 2013 case, Jatyapal Singh, which basically again the court is sticking with the traditional narrow Ajahasya test, and even in the public defining what is a public function, the court is saying something similar, which is very absurd to me. For instance, they are talking about, the Supreme Court is saying that all telecom operators are providing commercial services for commercial transactions, and that's why it cannot be a public service. So telecommunication is not a public importance function as per the Supreme Court this 2013. So I will not have time to go through these further more recent cases where the Supreme Court is sticking with the Ajahasya mindset, which was developed in the context of public sector enterprises. So my suggestion is that based the view of overseas developments, international human rights law, and even if we look at the Constituent Assembly debates, the Indian government should consider whether we need to expand the concept of a state under Article 12 of the Constitution. Thank you very much.
Thanks, Surya. Yeah, our next speaker is Prabhash Ranjan. He will be speaking on is from the South Asian University, and he will be speaking on the on the law treaties.
Thank you so much, Professor Rai. When you are one of the organizers, it is very challenging to also present a paper. But I hope I will do justice, and as Professor Rai mentioned, that all of you will be awake to listen to my arguments. I'm going to present on a topic which I have been working for some time, and in fact, if Professor Singh remembers, I worked on this at NUJS. Professor Singh supervised this work. The central idea here is that the international economic treaties which India has been entering into should have a greater parliamentary control or supervision, which is not the case right now. So I argue that there should be greater parliamentary control or supervision on international economic treaties that India has been entering. Now, before I come to how it should be done or why it should be done, etc., I need to make it clear that why am I talking only of international economic treaties, and what do I mean by international economic treaties? To answer the second question first, what I mean by international economic treaties here is trade treaties that India has entered, which obviously includes WTO and a slew of free trade agreements or free trade treaties which India has signed, and numerous other bilateral investment treaties. One can obviously argue that double taxation avoidance agreements are also international economic treaties, but I have not looked at double taxation avoidance agreement for the simple reason I don't have expertise on taxation. So it's not for any other reason. So I focus my work on international trade treaties and bilateral investment treaties or investment treaties. The second question obviously would be that why look only at international economic treaties? Why not look at all international treaties which India has signed? And this is a legitimate question to ask because in the Indian constitution there is no hierarchy of treaties which is mentioned anywhere. In fact, the term treaty finds mention in Article 51 of the Indian Constitution, which imposes an obligation on the state to foster respect for international law and to honor international treaties. Then the term treaty finds reference in Article 253, which empowers the Parliament to enact a law if an international treaty has to be given effect to. And then obviously we have entry 14 in the Union list, which talks of two things. First is entering into treaties and implementing treaties. So there is no segregation. The Constitution does not talk of different kinds of treaties. So why am I picking up only on international economic treaties? Now, there are a number of reasons why I'm picking up only on international economic treaties. And the first and foremost reason is that international economic treaties impose much more onerous obligations on the country in comparison to other treaties. For example, if we take the WTO treaty, the number of laws that India had to change because of the WTO treaty obligations far outweigh the number of laws which India had to change because of international human rights or international environmental treaties, etc. The second reason is that these treaties have attracted a lot of attention, not just in the public space but even in the parliament. For example, if we look at the parliamentary debates from 1990 till 1995, that was the time when the WTO treaty was being negotiated, there were a number of interventions made by many parliamentarians on concerns about implications that WTO treaty will impose on India and the need to have greater parliamentary control or supervision of these treaties which the executive is signing. This concern has been there for last 2 decades almost when it comes to trade treaties. This concern has also now emerged when it comes to investment treaties because now India has, at least the parliamentarians and the policymakers have realized, the academics working on this knew this all through, but the policymakers and parliamentarians have realized now that even these investment treaties can bite us and impose very onerous obligations. So it is this the severity of the obligations which perhaps make these treaties different from other treaties like human rights treaty or environmental treaty. This is not to suggest in any way that other treaties are not important. I am not placing trade and investment above human rights or environment, but I am only trying to make a case that these treaties have a different kind of obligations in comparison to other kinds of international treaties. That's point number one. Point number two, these treaties also have a very effective enforcement mechanism. For example, if we look at public international law in general, and if we take the ICJ statute, if a country does not abide by the ruling of the International Court of Justice, what sanctions can be imposed against that country? The ICJ statute is absolutely silent of this. The only sanction that can be imposed is if the UN Security Council agrees to do something. And we know that given the political nature of the UN Security Council, it never agrees or comes to a decision. So basically it means that even if a country does not obey the ruling given by the ICJ, there is no mechanism which can force this country or sort of compel this country to comply with that ruling. And this has led eminent international lawyers like Malcolm Shaw, for example, to argue that it is precisely for this reason that many ICJ rulings are not complied with. Now compare this with something like the WTO treaty, which is also a multilateral organization just like the United Nations is, and has almost 160 countries as its members. Within the WTO, if you do not comply with the ruling given by the WTO's court, which is the dispute settlement body, then the WTO treaty has a provision which allows the other country to impose a cost on you in the form of suspension of concessions, or colloquially it can be called as trade sanctions. Now, if these trade sanctions can be imposed, then there is, in a way, it forces the other country to comply with the ruling which has been issued by the WTO's highest court. Again, when we come to investment treaties, if you do not comply with the ruling given by Investment Treaty Arbitration Tribunal, there are significant damages which you have to pay to the investor. So there is an economic cost attached to non-compliance when it comes to trade treaties and investment treaties. Similar kind of economic cost is not attached when it comes to other public international law violations. If we take international human rights, for example, the only mechanism to enforce international human rights is through persuasion and embarrassment. You have this mechanism of reporting where it is reported what is the track record of this country in implementing international human rights law, and through that it is expected that there will be embarrassment and persuasion for this country to implement international human rights law. So the nature of enforcement again is very different when it comes to trade and investment treaties in comparison to other body of public international law. The third reason why, in my view, these treaties need to be looked separately is that there is often a question of democratic legitimacy of these treaties. Now, this question at a conceptual level is perhaps not sustainable for the very simple reason that any international treaty is a treaty which the state has entered, and the state, when enters a treaty, exercises its sovereign function. So the state voluntarily accepts certain restrictions on the exercise of its sovereignty. That is precisely the very nature of public international law. Now, if you say or if you argue that international economic treaties lack democratic legitimacy because they do not undergo parliamentary approval or parliamentary ratification, then that's an argument which can be applied to all international treaties, not just to trade and investment treaties. Now, why I'm talking of democratic legitimacy is because many scholars in India, and I'll quote Professor Chimni, for example, who is the foremost international law scholar from India, has called the WTO as an imperialist organization. Now, obviously, we know that Professor Chimni looks at international law from a Marxist perspective, and a longer critique for that can be done at some other point of time. But WTO is an imperialist organization because it imposes these economic costs and because the treaty has not been approved or ratified by the parliament. So this democratic legitimacy of international economic treaties is always a question that needs to be dealt with. And now I come to the second part of my paper, which is that can these questions be addressed by revisiting the role of the parliament when it comes to international economic treaties? Now, as I mentioned about entry 14 of the Union list, which talks of entering into treaties and implementing treaties, which means that, and by virtue of Article 73, this power extends to the Union government as well. The central government can enter into a treaty, which means signing a treaty, and can also ratify the treaty, which is the practice in India. It is important to keep in mind that under international law, ratification is completely an affair of domestic law, which means that how a country ratifies a treaty, international law does not answer that question. That question is to be answered by the domestic law of the country. So a country can always decide that whether the executive will ratify, whether the parliament will ratify, or whether somebody else will ratify. Now in India, although we have this entry under the Union list, but the parliament so far has not passed any law on this particular topic, which basically means that today the executive can sign and also ratify international treaties without taking the parliament on board, without the approval or without even discussing it in the parliament, as it happens in many instances. Now, the next question would be that even if the parliament is not involved in the process of ratification, the parliament will get involved when this treaty has to be transformed into a domestic law, which is absolutely correct. But we need to understand the distinction there. When the parliament looks at the transformation of the treaty into a domestic law, the parliament is not deciding on whether the country should be bound by that international treaty or not. That question has already been decided. Even if the parliament decides that we will not incorporate or transform this international treaty into a domestic law, that international treaty continues to bind India under public international law. Which means that if the parliament does not transform the treaty, India will be in breach of its public international law obligations. There might not be any domestic law breach, but there will certainly be a breach of public international law. I'll give you one example for this. When the WTO treaty was negotiated, came into force in 1995, India had to change its Patent Act. It was changed over a 10-year period by 3 amendments.
In the first amendment, there were certain things which had to be incorporated in the Patent Act. The Indian government introduced a bill in the Lok Sabha in 1996, and that bill was passed. However, that bill for some reason could not be passed in the Rajya Sabha, and that parliament was dissolved in 1996 when the Narasimha Rao government completed its 5-year term. Then what the Indian government did was to come up with an administrative order to implement its WTO obligations. Now this was challenged by US at the WTO's dispute settlement body, saying that India has not complied with its WTO obligations. In other words, this example clearly demonstrates that even if the parliament fails in transforming an international treaty into domestic law, that international treaty continues to bind India internationally. And of course, the WTO's dispute settlement body came to the conclusion that yes, India is indeed in breach of its international law obligations. So therefore, it is often, this distinction often gets blurred because it is often argued that anyway the parliament will look at the treaty when it comes to transformation. But there the parliament is looking at the treaty from a completely different perspective, not from the perspective of whether it should bind India in the first place or not. This is for those treaties where at least incorporation or transformation into domestic law is required. But there are many other treaties, for example bilateral investment treaties, for which there is no transformation or incorporation required. You don't need to change any domestic law because you have entered into a bilateral investment treaty. So, if we take the transformation of the incorporation logic, then the parliament will never get an opportunity to debate or discuss that particular bilateral investment treaty. Now, obviously, by this, one critique can be that parliament can always, there are different methods available in a parliamentary democracy where the parliament can always raise questions or issues which are of importance. So they can always raise questions or issues of investment treaties even if they don't require incorporation. But the evidence of the last 2 decades suggests that it has never happened. In 1994, when India signed the first investment treaty, till 2011, for 17 long years, there was no debate in the Indian Parliament on bilateral investment treaties. Although these treaties impose very onerous obligations on India. So that clearly demonstrates that although theoretically Parliament is empowered to discuss it, debate it, criticize the government, put pressure on the government, but the Parliament has not done that. And therefore I come to the final part, the proposal, which is that in order to increase the parliamentary scrutiny of trade and investment treaties, what needs to be done is to enact a new law. There is no requirement of any constitutional amendment or anything of that sort. The Constitution clearly provides under entry 14, as I mentioned, that such a law can be enacted, and that law can spell out the mechanism which the executive has to follow when it signs a treaty, international economic treaty, and how it has to be ratified. Now, there are 2 examples or 2 sort of models which can be followed. The first model is one which was presented in the form of a private member bill by Mr. Prakash Javadekar, who is currently the Union Environment Minister. In this bill, Mr. Prakash Javadekar argued in a private member bill that every treaty, he didn't make any classification of international economic treaty or other treaties. He said every treaty will be ratified only if it is approved by both the houses of the parliament. And in other words, if the parliament does not approve the treaty, that treaty is not ratified and therefore it does not bind India under international law. Now, whether this is a feasible model to follow, I don't know. Given the fact that the parliament hardly functions, it is quite possible that parliament will never ever debate on the merits or demerits of a particular international treaty. But nevertheless, theoretically speaking, this is a model which can be followed. The other model, which perhaps is not as strict as this, which does not require a parliamentary approval in the terms of voting and deciding, is for the executive to at least table the international treaty before the parliament for at least 15 days or 30 days. This is a system which Australia follows, for example. In Australia also treaty making is solely executive's prerogative. But the executive has to table the treaty before the Australian Parliament for 15 sitting days. It also has to present what is called as the analysis of national interest in terms of how national interest will be served by Australia entering into this treaty. And then Parliament has the opportunity to debate on that particular treaty, and then the executive has to take that debate or has to take the concerns of the parliament on board while ratifying the treaty, which means it can then go back to the treaty partner and say that we want to renegotiate this part, we do not agree with this part, we want to delete this part, etc., etc. But there is some kind of parliamentary scrutiny available. Now, in case of India, I argue that perhaps the second model would be a preferable model, where the executive necessarily has to table these treaties before the parliament, and then parliament should get an opportunity to look at these treaties, examine them, and then debate on them, and which the executive should take into account while ratifying the treaty. This hopefully will take into account the concerns of international economic treaties not being democratically legitimate, which in the first place I think is a wrong argument to make. But secondly, it will also help the parliament to debate and discuss and ensure that those provisions which are too stringent and which are not in the interest of the country should not be agreed by the executive. And this is certainly preferable to the status quo that we have, where the executive silently signs into a treaty and which the parliament hardly gets a chance to debate. I mean, I know there are certain exceptions to this. The nuclear deal with the US is clearly an example where the parliament debated intensely. But that was also because it had to be transformed into domestic law. I also want to finish by one more caveat which I didn't make at the beginning, that although the constitution does not categorize into different treaties, but there is a requirement where if any agreement involves cession of Indian territory, then that has to be approved. That has to go through the parliament because it requires a constitutional amendment. So, for example, in the recent land boundary agreement of India and Bangladesh, the constitution had to be amended. So, it is only those land boundary treaties or agreements which necessarily have to go through parliamentary approval. But for other treaties, presently the mechanism is of very limited parliamentary scrutiny, and in my view, I submit that this needs to change towards a greater parliamentary scrutiny. Thank you so much.